make sure you're turning your mic on.
Want everything? Have roll call, please, somebody?
John Sarantopoulos,
Here.
Brian Card,
Here.
Mike Yuko,
Here.
Lorraine Lagarde, Norm Farren,
Present.
and Keith Thurlow.
Present. Okay. First, I'd like to welcome Norm Farren and Lorraine Lagarde.
Can you hold on one second, Keith?
Oh. Oh, this is electronic, supposed to speed things up.
It's been a long time since we've done this. I'm just going to say for the record that the roll call was called John Sarantopoulos, Brian Card, Keith Thurlow, Mark Yuko,
Mike,
Lorraine
you.
Lagarde, and Norman Farren are all here.
Okay. Once again, congratulations, welcome aboard, Norman and Lorraine. And congratulations, Mike, for moving up, I think. I'm not sure, you tell me after a year of it and see. And I want a motion to move up because this is a class, we're gonna have a class tonight, really no business. But I need a motion to move that to do the rest of the agenda as much as we can before he gets here. You know, the adoption of minutes and
So you want to move,
seating of alternates. We alternate. We've still got one short, right? Because, all right. So, Lorraine, you're first, we'll let you go first as an acting voting member. And then next time, you might need to remind me because I don't always remember that well. And we just go back and forth. And agenda addendums?
not at this time, but if I remember correctly, what you want to do is you want to move section 9 up after citizens' comments? Is that what you want to do?
Yeah.
Okay.
Can I have a motion to move section 9 after citizens' comments?
Make that motion.
Give a second.
Second.
Any further discussion? All in favor, say aye.
Aye.
Opposed or abstentions? Okay, so citizens' comments on items not subject to public hearing, limited to 3 minutes, aggregate of 21 minutes. Public comments can be emailed to publiccomment@killenlyct.gov or mailed to the Town of Killenly, 172 Main Street, Killenly, Connecticut, 06239. All public comment must be received prior to 2 p.m. the day of the meeting. Public comment received will be posted on the town's website, killenlyct.gov. As this is a hybrid meeting, citizens can participate in the citizens' comment by WebEx, join by phone 415-655-0001, access code 2633-579-7439. Any public comment that's, we have no public hearings, so.
So that's good. Ed Grandelski, 877 Upper Maple Street, also council member. I bring to your attention Exhibit 1, Planning and Zoning Commission meeting, November 20th, 2023, page 12 of 15. 536, 542, 552 Hartford Pike. Specifically, 2 items are circled on the documents that you have. I quote on the first circle up, the upper one, CTDOT approval be submitted to the town prior to construction. Any modifications noted to be completed by the applicant. Second circled item, John Sarantopoulos asked about DOT approval. Mr. Card explained that it had not been received yet and that they have to submit it as a condition of approval. I bring to your attention Exhibit 2, the zoning permit number 24000105, Hartford Pike. This was dated February 16th, 2024. Again, on that document, it said conditions, zoning approval, applicant approved per special permit number 231314. Now, and it states copy of DOT approval and that the parcels have been merged is required prior to start of construction. That's on that document. Exhibit 3, building permit, number 24000105, Hartford Pike. same address, dated July 23rd, 2024. Specifically, one item is circled. Under conditions, zoning approval. Applicant approved per special permit number 231314. Copy of DOT approval and that the parcels have been merged is required prior to start of construction. Exhibit number 4. This is the building, I don't know what you call it. It says comments list that they keep track of inspections with the projects. So on 8/24/24, footings okay per TB. On 9/4/24, concrete walls okay per TB. Now, and I bring your attention to Exhibit 5, the CT DOT document dated October 1st, 2024, specifically addressed to Mr. Matt Baldino, PTOE, Solly Engineering LLC, 105 Main Street, Suite 2A, Monroe, Connecticut. Subject, commercial development, 535, 542, 552 Hartford Pike, Route 101, Town of Killenly. I look at these documents and I don't know, I come to the meetings, listen to what's going on. Maybe I don't agree with what the decisions are by the Planning and Zoning Commission members, but whatever. It's very disheartening that I have to be here. So let's look at Exhibit 1 from the P&Z Commission. This is a regulatory body. They specify certain conditions for approval before construction begins. Now, Exhibit 4, Exhibit 4, the building permit comments, identifies inspections for the buildings, items 8/22/24, 9/04/24. These were performed before the DOT approval dated on 10/1/24. Now, the request by the applicant for the DOT approval was dated January 2nd, 2024, and you'll see that in Exhibit 5 in the DOT, I don't know what you call it, but it must be the approval letter. I question the reasoning for a Town of Killenly zoning permit being issued a month and a half after the applicant made the DOT request. So a lot of this is, so everywhere you see it, all the documents, everything by commission members. Thank you, Mr. Attorney. I wish you were here sooner to see what my comments were, but I'm sure you'll get them. They started work, and we inspected work before the October 1st DOT permit. This fries me. No one's paying attention. No one is following your directives. And also, where's the applicant's culpability in starting construction before all the approvals were in place? The applicant made the request for the DOT permit. Everything was done through him. But still, construction had to start before, I guess it was August 23rd, 2024. Now, then, where is staff oversight in allowing start of construction before all the approvals are in place? I have a problem with that. I keep getting comments, well, staff doesn't drive on 101 too often. Give me a break. For someone to make that comment, that staff doesn't drive by and whatnot, again, no one pays attention to what's going on. It was interesting because I was asked by a resident of Killenly in August if the DOT approval was submitted to the town. My comment at the time was, how could any entity start a project like this without all the approvals in place? Obvious, I was wrong. I should have came in right at that point in time and said, where is the DOT permit? I would not be here if not for the fact that I had to call DOT Norwich late September regarding, excuse me, an issue at the site. I happened to be going by shortly after I made the call to Norwich. The DOT inspector was on site. I invited myself to a meeting with him then and there. He said he did not like the situation and he was going to talk to the powers to be on site to fix the situation. Okay. Now here's another comment. He further stated at that time there was no DOT permit for the site. That I don't think he was supposed to tell me at the time. Okay, intrigues me. I'm busy, I don't have time. I go down to Norwich, I don't know, a few weeks later, stopping at DOT. They would not give me a copy of the permit. I'm trying to go through different things. I was going to go Freedom of Information, but I have a life outside of the town. And it's kind of difficult to I hate being here right now. But anyway, again, he said there was no permit for the site. And it's like, what the heck is going on? So I don't want to be a jerk. I'm not going downstairs to ask the question. I'm going to find out on my own if I can. Well, lo and behold, a week and a half ago, I get the DOT permit down in my box. So, okay, here it is. So obviously, things are going on that aren't following the proper protocol. And I don't know where to go with that, except be here, bring it to your attention, and because you guys are the regulatory body, you should tell staff to jump, and they should say how high. In this situation, I had a paper trail to identify that the rules and decisions of the Planning and Zoning Commission were not followed. In how many other instances are decisions of a regulatory body, P&Z, et cetera, not followed? You know, this is, I had some interest in this particular project because I didn't kind of like what was going on. I go by there all the time, and I get caught in some of the stupidity over there. I get caught in traffic jams because the contractor has no clue. The specific reason why I called the DOT guy was I'm trying to get through, but there's a tractor trailer trying to make a delivery to the site. Nobody on the site could care less and help him out. So we got traffic backed up to 395. I'm in traffic, not quite to the firehouse, but somewhere in between. So again, I have DOT's phone number. I'm going to make the call. And, you know, when he, like I said, he came out, he said there were issues and he was going to take care of the situation with the powers to be. But again, in how many instances do you guys make a decision and the contractor proceeds, staff proceeds? This situation here is not in the best interest of the town of Killenly. Thank you.
Thank you, Ed. Anybody else want to speak? Public comment?
Ulatique Barclay, 26 Dark Lantern Hill Road, resident and also counselor. I'm going to weigh in on the same project that Ed was talking about. So the in Village Commercial, the building is supposed to be in front and the parking is supposed to be in back. A variance was granted because of the topography of the land. The developer took that land down to ground level. So why? That's a lie from the developer. I know Brian's always asked about how much fill is going to be removed. I don't remember if he asked for this specific project, but if you go and look, they took it down to the ground. So there was no need for a variance on that if they would have told the truth. Thank you.
Anybody else want to make a comment?
Hello. My name is John LaBelle, 57 Island Road, Dayville, Connecticut. First of all, I want to say thank you for everyone who serves on here, and congratulations to the new members, and I wish you well and Godspeed in your decisions. I also want to thank those of you that sent me a little note while I was in the hospital. And hello? Hello?
Might want-
Is it on? I want to thank those of you that sent me a note while I was in the hospital. And I just want to comment on, over the years, I have more than 3 minutes of stuff to talk about. However, I want to express my gratitude to everyone, and especially Day Kimball Hospital. Over the years, it's had a reputation of so-so. But the time I spent there over the past month, I have to tell you, it's become a place of professionalism, and I was very impressed. I didn't know if I was in Day Kimball or Hartford Hospital. That's where they're at. And, let me tell you, that's the third time I almost died. They took care of me, and here I am to help you along the way with your work. So thank you for those who recognize that they appreciated what I was doing. What this young lady said here about the excavation of the site is true. In their presentation, they said, well, we want to maintain the integrity of the site and the landscape and the integrity of the neighborhood. They cut that site down to the sidewalk, and they had a huge berm there, probably maybe 25, 30 yards of loam. I'd like to know what they did with that loam. But anyways, there are a number of things that they did that, I know staff here is very busy and probably understaffed. I would encourage this organization to look at what people are assigned to do and how much time they have to do to verify, validate, and approve. When we ask one of our employees to sign off on something, they should be sure what they're signing off on, because quite frankly, if they're signing off on something that is inconsistent with your regulations, they have been forced into a position of fraud. Fraud. And we, as a community, cannot allow our employees to feel like the pressure is such that they have to sign off on something that they may not be totally familiar with. And I would encourage the staff that are hearing me, do not sign something that is a legal document that you are unsure of, and don't be afraid to check, even with the auspicious attorney who's here. This attorney represents the community, not just the zoning board. All the employees and all the citizens of this community are represented by this person here. You have a form that builders fill out. How am I doing on time?
Fine, John.
Okay. You have a form that the proposed builder fills out. And on that form, it lists everything that, sorry to hit that. It has everything required of them, which included a copy of the DOT permit. I called the DOT myself. They said, well, we're working on it. I think we have it. I said, well, okay. What's the number of the permit? Cannot tell you that. Let me tell you, if you go into statute, they're required, any citizen that calls for information, to give them that information. So I asked them twice. I called the second office. Said, sorry, you have to talk to that person you talked with in the first place. We'll transfer you. They transferred me. I talked to that person again, and I said, would you please? I'm an architect, I'm a citizen of the community. I know what I'm going to be looking at. Could you at least tell me the number of the permit? Because I couldn't find it on site, and they are supposed to put it on site. My point is, God keeps me here, and I believe the reason he keeps me here is to help my fellow citizens. I have a lot of expertise in my brain. Don't be afraid to use it, because at my age, it's only going to be there that long. John Serentopoulos and I, we know each other very well. We don't always agree, but we maintain our relationship, so, don't be afraid to speak up, speak out, and question. You all have a fiduciary responsibility that is the greatest responsibility in this community. And if you look at the town regulations, the statutes put a lot of responsibility and liability on each and every one of you. And I've always been very cautious wherever I work to make sure that I was protected. And be cautious, because the insurance that the town says they provide for you, officers and directors insurance, only applies if you have exercised your actions in accordance with all laws. You break one law, and they don't have to protect you, I think. So, I'm here to say hi, welcome back. And there was,
Can you
I
just
couldn't
start
find.
wrapping it up, John?
Okay, just 2 seconds.
Yeah.
Whoops. In the minutes of the meeting with the progenitors of the battery project, there was a reference to NTE. I want to reiterate, NTE no longer exists as far as ISO New England, the state of Connecticut, and the state of Delaware concerned. It is illegal to try to exhume legal documents from a corporation that's been dissolved. You can and I've got the paperwork where it talks about how they're dissolved and henceforth no longer exist, and they cannot be recreated. Okay, and that refers to their permit, which they don't seem to find. I know where it is, but they can't get it. Thank you very much. Appreciate it.
Thank you, John. Anybody else want to speak to this commission? Okay.
Ed Grandelski, I would like my comments to be at verbatim in the minutes of your meeting tonight.
Okay, Anne Marie, you got that right. Okay, we're just gonna go through, because this is an educational meeting, but if we could take the time to go through, finish this, because we just gotta accept minutes and stuff. No unfinished business, new business is town attorney, so we're moving up to 9, adoption of minutes. Can I have a motion, please, for the minutes?
All of them?
Yeah, we can discuss whatever ones you want, yeah.
Make a motion to accept the minutes.
Second, any discussion on any of them, any errors or omissions?
Just
Okay.
a clarification, that's for all three, the dates November 18th, November 20th, and December 4th, is that correct?
Yes,
Okay, I just want to make sure I have that reflected in the minutes, thank you.
sorry.
That's okay.
Can I have a motion? All in favor, say aye.
Aye.
Opposed or abstentions? Okay. Other miscellaneous. Connecticut Land Use Law for Municipal Land Use Agencies, Boards, and Commissions, Saturday, March 22nd, 25th. You were just letting us know there's an educational seminar, correct?
Yes, this is an education.
No, this other one there.
Oh, yes, Connecticut. The Connecticut Land Use Law. This is the educational seminar that happens once every 2 years. For those members who were here 2 years ago, you'll remember that we had everyone in this room, and we ran it on the big television screens. What I need to know is those that are willing to attend, so we can file our request to be part of it.
I I'm willing to attend.
Okay, Lorraine is a yes.
Anybody else?
Norm, okay.
This public citizens, John
Becky,
was.
you?
What is the date of that?
This Saturday, March 22nd.
March 22nd. The town will pay for the, we have to get booklets. The town will pay for the booklets for the commission.
Okay, department reports, zoning and inland wetlands, anything to report?
Nothing at this time.
Economic development?
There was a ribbon cutting for the Killingly Discount Liquors in December at 734 Hartford Pike, the old Spirit of Halloween end cap. And on February 13th, the Northeast Chamber of Commerce is hosting an after hours in the 140 Main building. It's open to the public. It starts at 5 o'clock, and they've invited all of the Main Street businesses to put up tables as well. And then the Rose Room Cafe is partnering with Logies at the Logies Greenhouse. They're opening up a little boutique coffee shop, so you can get your coffee and browse and have 78 degrees of tropical weather in the middle of February, so stay tuned. Our next EDC meeting is March 4th.
Okay, town council?
We had a public hearing for the Vision Committee, and there were really no comments submitted. We discussed the terms of the Planning and Zoning Commission members, and we have the dates of those all set up. Several appointments to boards and commissions, Norm and Lorraine, to the Planning and Zoning. And the town elevator has been fixed. The footbridge in town, the engineering department is engaging a consultant for the repairs. And I requested information on the Northeast Department Health, their dollar per capita increase, and where they stood with the other departments of health. There's a tax abatement program for residents that they can apply for elderly homeowners to freeze their taxes, and they can apply between February 1st and May 15th. We had the budget calendar, because budget for next fiscal year will be starting. There is going to be a program at Killingly High School for the Korean and Vietnam War veterans, Tuesday, February 18th at 4 o'clock, hosted by the Lieutenant Governor. And we approved the ordinance for the formation of the Vision Committee, and then also we had new business was a discussion and action of implementation regarding boards and commissions, and that was what Ed spoke on, that guidelines and all of the work that Planning and Zoning Commission has put forth, and not being followed by staff. And that's it.
Thank you. Okay, now back to section 8, new business. Mr. Slater, the town attorney for land use. You're gonna do a presentation.
I can give it to you. Where do you want to be? I mean, I got batteries, so if this works for you. Yeah, Enter Eric, it works. It's also being shared.
Excellent.
It's also being shared on WebEx. We do have one member of the Zoning Board of Appeals Jared on, but it's not a quorum. They were invited.
Yep, and as I indicated to staff, there's a provision of the Freedom of Information Act that if you invited members of another commission to your meeting, and it turned out there was a quorum of that particular commission here, that wouldn't constitute a meeting. It would be your meeting, and they wouldn't have to do a second notice. Every now and then, groups, two different commissions like to hold a joint meeting, and they'll each notice it, and they'll each call it, and that's fine too. But it just as an FYI, it is permissible to invite members of another commission to your meeting, and even if they're a quorum, it's not an FY violation if they didn't notice it separately. So my name is Ken Slater. Welcome, new members of the commission, and welcome to the movement from alternate to full members of the commission. For those who don't know me, I'm a partner, actually managing partner of the firm of Halloran and Sage. We're town attorneys. I do a lot of land use work. In fact, I'm on the executive committee of the Planning and Zoning section of the Connecticut Bar, which is the organization that puts that 2-year program on. I'm also one of the presenters for the Connecticut Land Use Academy. There's also the ability to do training on demand, or we used to go county to county way back when, but now those trainings are always held at the Yukon Extension in Haddam. But we do that training, so I'll be sitting behind a computer now that they do them online. They used to always be at Wesleyan. Now that they do them online, people are able to put questions in the comments, and I'll be furiously clicking away on a computer behind the scenes to try to answer questions. So tonight's session, which really is not focused strictly on Planning and Zoning Commission, but has application to any land use commission. It relates to some of the do's and don'ts and tips about running effective meetings and hearings. Some of this has been part of prior training sessions, but it's been one part of a broader set. So this is a focus on this section, which is appropriate. We also thought, tonight ordinarily on the agenda, you might be doing election of officers, et cetera, but with the appointments still going underway with the commission, it seemed to make sense to hold that agenda item off for another month, and then we can do a training session tonight.
Mr. Slater, can
yes,
you hold on a second? You guys hear all this back there? Okay,
Good,
just making
good.
sure he's got the mic quite a ways
Good.
away.
Yeah, I
so
can move it a little closer too, just in case it's not coming across than online folks. So, the first thing is just processing applications when you get them. There's a receipt dates, and that's based in the statute to make sure that applications get processed. Where they're really important for the planning and zoning in particular are on subdivisions and site plans, because if you don't act in a timely fashion under the statute, then the applications can get automatically approved. Zone change applications, special permit applications, and anything the ZBA does, there's no automatic approval, even though the statute says that you shall act within a certain period of time. The Connecticut Supreme Court has said that that's just directory, that's advisory to the commission. The only time where there's a consequence for missing the deadline is if the statute specifically says what happens if you miss the deadline. And again, that's the subdivision, that's re-subdivision and site plan. And so the receipt date is the next regularly scheduled meeting or 35 days, whatever, if for some reason, weather, quorum, whatever, causes the next regularly scheduled meeting to not be more than 35 days after it's received, then the 35 days is what applies. If there's going to be a hearing, it has to be within 65 days of acceptance. Once the hearing is open, closed in 35 days. And then ordinarily a decision needs to be made 65 days thereafter. If an application proposes an activity that's regulated by the Wetlands Agency, you're given a little more time because you need to receive their report, or maybe you're given more time. It all depends on if it's simultaneously and they haven't reached their decision in giving your report in time. You have at least 35 days after they give you your report to make your decision. And also, the applicant can give up to 65 days of consents that can be to any one of those deadlines. And our recommendation is you get those in writing when they're granted. So regular meetings, and I touch on this on another slide too, the public's not entitled under law to be able to be heard at a regular meeting, but you have the discretion to allow it. And as I point out in a later slide, that discretion could be on a case-by-case basis. It can be by way of the chairman who sets the agenda, having a audience of citizens type session like we had this evening, or your rules. In your case, I think your rules do provide for it, that you provide for some public comment on items that are not on the agenda. But if it's a matter that's on the agenda, you do have the discretion. If someone has unique information that you think would be helpful, you are permitted to allow it, but there's no right to do that. Public hearings, on the other hand, there is a right to be heard. And that right is not just to citizens in the town of Killingly. A public hearing is a public hearing. So if sometimes commissions don't realize this, but someone will come from a neighboring town or from a statewide organization or something and will want to make a presentation, and folks think that they can stop them from presenting because they are not residents of Killingly. That's not the case. They actually can be heard. Typical sequence during the hearing, there's no rules for it, and there's no specific requirement unless you've adopted a bylaw that specifically says so. But typically, an applicant gives the presentation, commission asks questions of the applicant, the public is given an opportunity to speak. Some commissions, will have a sign-in that you go in the order of the sign-in. Some commissions will ask for people who vote who are in favor, then opposed, or some people who don't have a position but want to make a comment. That's quite often the case. You can set time limitations, but hearings have to be fundamentally fair. So if there's a situation where you've got an applicant that comes in with experts and a big long presentation, and a neighborhood group forms and they engage an expert, have a lawyer, etc., telling them that they only have 3 minutes to make their presentation when an applicant has had an hour is a problem. And on the other hand, when you have a room full of concerned citizens, if you didn't put some kind of a limitation on them, then not everyone's going to have an opportunity to be heard. So it's important for the chair to sort of set that expectation, make it clear, as I'll touch on a slide down there. It's not a popularity contest. The number of people in the room doesn't guide how you should be interpreting and applying your regulations. So if you can discourage people from getting up and saying the exact same thing that 12 other people have said, and you just you say, obviously you're here, we understand your concerns. If you can persuade people that they don't need to repeat what others have said, then that's great. People have a right to do that. But a good practice to have is to just use a common sense rule. If people have hired experts, have organized, and they have a longer presentation, use your discretion and allow them to spend more time. And in terms of the general public, if you hold them, that haven't organized, haven't hired people that have a longer presentation, if you hold everybody to the 3 minutes, then at the end, after everyone's given an opportunity to speak, the person who might have had more to say, you can give persons some more time. That way, they're given a fair opportunity to present, but you've managed a mechanism in which you try to get as many people to be able to comment as possible. Ordinarily, you want questions to go through the chair. You want to keep decorum. There shouldn't be individual persons speaking to one another. It's important to try to set the stage for good decorum and good behavior in meetings. There is a right, if somebody requests it, for cross-examination. The only time I've seen it in land use commissions is when a lawyer asks to do that, because sometimes it is clunky when you want to ask specific questions of an engineer who's made a presentation, and to say, Mr. Chair, will you please ask Mr. Smith what he meant when he said this? It can be kind of it can waste some time. So if normal questions come through the chair, but when someone asks to be able to ask a witness specific questions, and they have to be relevant. The chair can always step in when someone is not, there is no First Amendment right to come to a meeting in a public hearing and just talk about whatever you want to. It has to be relevant to the application that's before the commission, and you can call someone out of order for not doing that. Obviously, you give some latitude to the public. They're not necessarily experts on things, so you give them some latitude, but you do have the ability to rein that in. But there is a case that if somebody asks for an ability to ask direct examination and you deny it, then you've denied them a fair opportunity or a fundamentally fair hearing. Site visits, when we're part of the public hearings, I mean, we recommend that if you're going to have one, that you have it as a special meeting and you notice it as such. Sometimes commissions will try to avoid that by sending folks that are less than a quorum. There's some FOI decisions that suggest that trying to get around when it's clear that the commission has a mind. It's one thing when you do a drive-by and an application is there, you as a member get familiar with what the property looks like when you're driving by. That's different. But when the idea is you really need to walk on the property to understand where things are, and you do that in small groups to avoid having a meeting, there's a risk under the FOI. There's some FOI decisions that suggest that that's really a meeting that you're having, and you're just not properly noticing it. So if there's an application that you really think you need to walk the site and see where things are, and maybe the applicant will be able to point out where things are going to be improved and things are being located, that you schedule that as a special meeting. You keep the minutes. The meeting shouldn't involve any discussion per se, other than explaining where things are and walking the property, and then the actual dialogue, specific questions about the application as it relates to what you've seen in the property could happen here during the public hearing, but you'll be armed with more information about the site. That's the ideal way to do that, because you're not going to be able to get the public to make comments and do all of that out in the field. It should just be the public can attend, watch you do your business, and just see where things are on the site. Virtual meetings, they now, post-COVID, they've allowed, fully virtual meetings as well as hybrid meetings. And I think more commissions who are still using technology as an opportunity for more people to attend are doing it like your commission in a hybrid format. And electronic access has to be provided to the public. So if someone doesn't have a computer and they make a request, through staff that they in a fully virtual meeting, a hybrid meeting, obviously they can come here. But if it's going to be fully virtual, a person needs to be provided an opportunity. So when that happens, a computer is set up in a room, or a room like this is set up with a connection to the fully virtual meeting, and then they have to do that. Votes, when they're not unanimous, and the first bullet where I reference votes by roll call, it's more accurate in that the second one where I reference a roll call. If the vote's unanimous, there doesn't need to be a roll call, because everybody watching knows what just happened, and if the chair announces that it's a unanimous decision, everybody knows. But if it's not unanimous on a hybrid meeting, it's more difficult sometimes to tell than if you're sitting here in the room who voted in which manner. So there needs to be a roll call when you do a vote if it's not a unanimous vote. All right, now, so if there are technology issues, I've got a matter right now where there was 2 hours of a presentation that the online, it was just blank. And so if you had connected virtually, you just saw a blank screen, couldn't hear anybody, couldn't see anything. If you find out that there is a technological problem, so that people who are on in a hybrid, there are ways that you can address that. If you can find out, I mean, sometimes you don't know till after, which would be unfortunate. But if staff gets a telephone call or something that says, wait a minute, there's a problem with technology. If it's just video, if someone's been able to hear it and no one has put exhibits up on the screen by sharing screens or whatever, and it's just testimony and you've heard it, well, that should be fine. You don't have to redo anything. But if exhibits have been presented, then you should ask the person if you can figure out. Ideally, someone says, yeah, you went out at 7:30 and you came back at 7:45. If you can get a basic sense of what was missed, then you could ask the person, whoever was presenting during that window, to present again. And that way, the people that are online will be able to see the opportunity, see what happened. The other, it's important part of that, if someone's absent from a meeting, in this particular matter I'm talking about where there was 2 hours missing, a member of the commission said, oh yeah, I wasn't at that meeting, and said, yeah, I've fully familiarized myself, I'm prepared to vote. Well, how do you fully familiarize yourself with what happened in 2+ hours of presentation when there is no audio, there is no video? So it's a case that hasn't been decided yet. It's been briefed, but I would suggest that if you were a participating member of the commission and you participated by virtual means, and there was a big chunk that you were missed, and you can't watch it, then you should recuse yourself and not vote and avoid the issue that's present in that other case, because it'd be hard to show that you could fully acquaint yourself with what happened if a big chunk of the meeting was missing. And if the hearing's been closed and you find out about it, then you just got to let it ride out. But if it turns out the hearing is still open and you find out afterwards, it'd be a good idea to allow the persons, or ask the persons who made presentations during the time where the technology has been out to re-present, so that people who only participated virtually will have an opportunity to see the entirety of the hearing, even if part of it's duplicated. So types of decisions, obviously you're going to prove it. Then there's modified, condition, and without prejudice. So I'll come back to with prejudice in a moment. But difference between a modified approval and a conditional approval. A modified approval, if an application's been presented and it's just missing a detail or something that you could incorporate in your motion would correct the problem. And say that it's missing plans are missing a compass rose, and your regulations specifically say that every sheet should have a compass rose. You could approve it with the modification that the plans be resubmitted with a compass rose on every page, or if there was a signature block that had a mistake on it, or even more substantive things like if there was a road grade that you realized when you looked at the plans, the road grade was in excess of what your regulations allow, and you were able to incorporate in the motion that I'll approve, subject to the modification that the road grade between station 110 and station 120 on the plans be modified so that it's at grade X. That'd be a modification. You're basically changing the plans that are approved. A conditional approval is when you're adding things. You're not just making the application fit the regs, but when you have a special permit, you have certain discretion. For example, maybe you are going to authorize a business, but you're going to limit hours. Maybe there's an excavation operation, and you're going to impose some kind of a limitation that's not specifically in your regulations, but given the neighborhood, you think that an additional requirement should be added to the approval. It could be the conditions having to do with reporting when construction is going to be starting, or having an inspection at certain points. Things that are not part of the application, things that are not proposed by the applicant, things that are not specifically called out in the regulation, but something that you wouldn't, without it, you might not approve it. And it's a good idea, especially if you're talking about important conditions and maybe an applicant is going to challenge the condition. If an appeal challenges a condition, a judge has to decide whether that condition is integral to the approval. Now, they can't get in your heads to really know, but the judge will look at it and just try to see how important of a condition that would mean, and whether there is a reasonable likelihood that you might not have approved it if you knew you couldn't issue the condition. One way you can avoid leaving it to the judge to try to make a judgment call on that is you can actually say the following conditions, which are integral to the commission's approval of the application, are blank. If for some reason the court decides that one of those integral conditions is illegal, what happens, it comes back to the commission again, and you decide, okay, now I know I can't put that condition on. Am I going to approve it now? I mean, you thought you could put this special kind of buffering in that would protect the neighbor. If I couldn't do it, I wouldn't approve it. Then your commission can reevaluate and either change the condition following what the judge said. Maybe the judge's decision gives you some guidance and you can fix the condition. Or maybe, without that condition, even though you initially said it was integral, you'll go ahead and approve without it, or you'll come up with something different. Or, as I say, maybe deny it outright once you know that you can't require that particular condition. Now, I've said over the years that, saying, something is denied without prejudice, what that really is a signal to the applicant that you're open to them coming back with an application that addresses what's missing. And I've always said that as long as it's clear during the discussion and your ultimate decision that the real problem the commission had was it was missing something that was important, you don't really have to say it's without prejudice. But I have seen some people, there's a rule called the rule where you're impotent to reverse. The ideal of commission's decisions in administrative law, and it's literally been more than 90 years, there's a principle that the commission's decisions shouldn't just be reversed. It's in law, when you talk about the Supreme Court, there's a concept called stare decisis, that only under unique circumstances should the Supreme Court reverse something that an earlier Supreme Court decision made. And the same kind of doctrine applies to administrative agencies, that you make an approval that something, qualifies for, I'll say a site plan and special approval. And you approved it, for whatever reason the applicant didn't get the project off the ground. Financing changed, circumstances changed, what have you. They come back with literally the exact same application, and there's no changes of circumstances. Sometimes with time you learn some things that if you knew back then you might not have approved, but if there's literally no change in circumstances, the commission should render the same decision it did before. And that's the impotent to reverse rule. And why I bring that up is if you make it clear that if somebody has a chance at approval and does a lousy job of it, and you deny it because they fail to comply with the requirements of the regulations, and then they reapply, an opponent might make the argument that they had one shot with you, just like when you go to court and you try a case and you lose it, you don't get a do-over. And so an argument could be made that they don't get a do-over. But if you say that this is being denied without prejudice because it's missing some items, you've really signaled the fact that the decision hasn't really been made by the commission fully on the merits. It's missing something, and it could come back, and it makes it less likely that somebody could make a challenge and try to say, this guy can't fix what he didn't do right the last time. You need to deny it. You denied it once, you need to deny it again. So it can be a good idea if there's just some procedural, something missing, and that you might approve it if they could fix that. And then obviously denial. Sometimes commissions get tangled up. There was a case called Merlot where there was a motion to approve which failed for subdivision. And there was no further motions. And so the applicant in that case argued that the commission failed to take action because it didn't pass any motion. Because the motion to approve failed, they didn't pass that, so they needed to do a motion to deny and have that carry in order for the commission to act. The court said no. If the commission takes action, a vote is held on it, and the applicant does not get enough votes to approve it, it's a denial. So some commissions will go ahead and do the double motion just because that's the way they do business, and that's fine. But you don't have to. What you need to do is you need to act. An application, some kind of motion, whether it's a motion to approve or a motion to deny, some motion has to be made and acted on by the commission within the deadline in order for there to be a decision. Reasons for denial. If you don't give any, and when I say the reasons for denial, there's a concept called a collective statement of reasons. If your motion has the specific detail in it, and it's seconded and approved, everything in the motion has been endorsed by everyone who's voted in favor of it. So one way, you can have all of the reasons for the decision would be to have it in a detailed motion. But if the motion is a simple motion to approve, and all of you have different comments that you make, those comments, you're not speaking for the whole commission. There may be some common elements about what you say. So if you don't all agree to the specific reasons in which it's going to be denied, then the judge's job is to see to basically make up the reason. Is there any legal reason that could support denial? And is that evident? supported by the evidence. So there've been some land use lawyers who say, well, don't give any reasons, so that way the lawyers have the best chance to try to figure out and support your decision. You won't make a mistake. Don't think that's really good land use policy. The better policy would be to, craft good motions, give people understand why you've acted the way that you have. And then, the downside is that if it's appealed, the court is limited to, was the reason that you gave a legal reason, and was it supported by the evidence? But more often than not, it's a good idea. I mean, a denial is a little easier in the sense that they didn't comply with the regulations. Maybe you could say why, and again, that might go strictly to the merits. That's just a bad location for that particular use. But it also might go to something procedural, and that would go back to the potentially without prejudice decision. But more often than not, we think it's a good idea to try to give some guidance in your decision making. But you're not legally, the courts say you're supposed to, but there's no consequence if you don't. Your decision won't be changed simply because you don't adopt a collective statement of reasons. Reconsideration. Generally speaking, don't do it. Robert's rules or other parliamentary procedure has a mechanism in which you can move to reconsider. A person in the majority on the vote can do it. There's one exception I will reference, and it so rarely would happen in a land use commission. Maybe during the meeting that you made a decision, suddenly you look down at the plan and you're advocating for approval, or let's say you're advocating for denial because the quantity of cubic yards of material he was removing was excess of what the regulation required. And you looked at the paper and you say, wait a minute, I did the math wrong. This complies. I made a mistake. All right, and if it's still during the same meeting, you could ask to retake up the matter and ask to reconsider, deliberate it, and the commission could change its decision. That's in the same meeting, because then once the legal notice is going out and notice is going to the applicant, that's really the decision. If the legal notice has gone out and a week later you put your head in your hands because you realize you did the math wrong, you really can't go back, because the decision's been finalized, it's been it'll be noticed, and you really can't undo what you did. But so there's very narrow circumstances. I've literally never had a commission that's done it, but that I've represented, but it is possible, but only on those really narrow considerate situations. So what do you consider when it's time to do the decision? All right, you should only be relying on evidence that came in during the proceeding. I mean, if it's not a public hearing, the information that's been presented by the applicant, and any of your consultants, if you had an engineer who gave reports, et cetera, that's what it should be based on. With public hearings in particular, anything. If you for some reason came into information, and I'll touch on it again, on what's called ex parte, which is information that you receive outside the context of the public hearing. If somebody ran up to you, the most clear classic case of this was a matter in which some member of the commission was given a map about a location of a well on the site, and was given this outside the context of the public hearing. Never brought it during the public hearing and said anything about it so that the applicant could say, oh, no, wait a minute, that well is not what's shown on that map. They brought it before the commission for the first time during deliberations. And that decision was reversed. That was not fair to the applicant or members of the public to be able to rely on a document as a basis for your decision that had never been disclosed. So let's say you're standing at the gas station and somebody's trying to present you information. First of all, try to act. Your judges. You're supposed to be neutral. Tell somebody, please come to the hearing. The public hearing is next month on such and such a day. We'd love to hear from you. I can't talk to you about this application. But if for whatever reason you can't unsee what you've seen, and somebody hands you a photograph and you think it's relevant, it's like, wow, this is something that the commission really should know about, then come to the hearing. Present it, the applicant knows about it, say, look, I was at the gas station, this neighbor came and gave me this picture. It seems to show that XYZ, that whatever you think is important, that the applicant should be able to respond to. Once the applicant sees the photograph, the applicant say, wait a minute, that's not my property. Look, see that oak tree? That's the oak tree across the street. They'll have an opportunity to respond to it. So if for some reason you do come into possession of evidence outside of the public hearing, you should avoid getting it if you can. Same thing, somebody tries to send you, you get an envelope in the mail, you open it up and you see it, it's something to do with the commission. Fold it up and don't bring it. But if you open it up and out comes this photograph again that you think looks really relevant, then you bring it to the hearing, you say how you got it, and it gives everybody an opportunity to comment on it. So another thing that shouldn't be a factor, land use is about the land. It's about whether or not the application proposes something that complies with the regulations or not. The identity of the applicant, or frankly, whether the applicant, is, from Killingly, or whether the applicant, is from Brooklyn, New York, that's really shouldn't be a factor in your decision making. It should be, did they present information that complied with the regulations? The same thing is, true about, you might have a local business that's beloved, and somebody wants to come in, and this hardware business has been in town for literally 150 years, and a major chain wants to come in and put in their hardware store, and it's going to be a competitor. If they meet all of the regulations, it wouldn't be a valid ground to say we want to protect, our existing business, even though in your heart of hearts, that's what you want. You've known those people, they've been here, generations have run that hardware store. You just hope that if the other one meets the regs, you hope that, people are going to support the local one, and they're going to continue to be successful. But if you denied it because you did not want to have competition in that particular line of business, that would be problematic if it was appealed. Another thing is about what's the role of just public sentiment, and you have a responsibility to apply your regulations, and a room could be filled up with a bunch of people that are really unhappy about something, but if it complies with the regulations, your responsibility is to apply your regulations. And so it isn't a matter of how many people are opposed or against. So in some instances, understanding what the neighborhood thinks when there's a regulation that allows consideration of impacts on the neighbors. It can be relevant to your regulations. If it ties to your regulations, then that information can be important. The same kind of thing. There's really a couple of different kinds. There's one formal kind of petition that relates to the Planning and Zoning Commission, and that is a petition to challenge the zone change. The old word used to be a remonstrance, but there's a statutory provision based on the people who the properties near and owners of properties near where the property is subject to the zone change. It's a technical statute. It's something you need help from staff to be able to determine whether or not the requisite number of signatures have been obtained so that it would require a supermajority of your commission to pass the ordinance. That's built into the zoning statute. There is not any process in which petitions related to, if you have a matter on before your commission where you're going to do a regulation change, or you have a special permit application, or you have something, there is no statutory mechanism. The mechanism is really information that you receive during the public hearing. That's really what it should be governed by, because you don't know when someone, just like you don't know all the information about an application unless you're sitting here listening to everybody, looking into the eye of the person who's making a presentation to you, judging the credibility of the information that you're getting. That's really what matters. What you don't know when somebody signs a petition is, the people who sign the petition, do they really know all there is to know about the application? If they were sitting in the room, would they have the same perspective? You don't know. Now, it can be received, but you just need to take it, a term that judges uses when they sometimes allow evidence that it may or may not be admissible. They'll often take it and they'll say, I'll give it the weight that it deserves. So I would suggest the weight that it deserves is recognize that we're the people in the public who've heard everything about the application, hear the presentation, see the maps, and then they stand up in the room and say, this is why I think it's a bad idea. That information is more valuable to you than someone who just presents a petition where a bunch of people signed it, and they might have just been buddies that just signed it, or again, there's just literally no way when they're standing out in front of the grocery store that they can have the full information about an application to know what their what their position is. So you can accept it, but it's important to recognize the difference between its value and the value of someone who's actually listened and then given you their opinion.
Ken, does a petition, doesn't it have to be certified that they're residents of the town by the registrar of voters?
Well, that's there's the petition. There is literally no petition. There is petition processes having to do with actions that the council takes and ordinances and things where they can force referendum and things like that. That's something where registrar of voters comes into. A petition that comes into a public hearing, it's the same as a public hearing. Somebody from Webster, Massachusetts can come and sit in your meeting and say what they think. So if they're from Webster, Mass, and they sign a petition that they think something is a bad idea, that because there is no real petition process in the land use permitting. Now, if it's a challenge to a zone change on that remonstrance statute, that's a different story. That has to be verified that the person actually has a legal interest to be able to oppose that, and that it may be registrar, but it may also be just the land records of whether or not who owns the land, and that has to be investigated to determine the valid petition. But just a standard petition that just somebody comes in and says, my neighborhood is really opposed to this, and it's signed, you don't have to verify who signs it, because it isn't a specific legal process that's recognized in your land use process. So you don't really have to verify it any more than you need to verify when somebody stands up. I mean, you ask them, what their name and address is, but you don't throw them out of the room if the person again is from Webster, Mass. Yes.
There's a petition that comes through,
Mm-hmm.
and it deals with people's rights,
Mm-hmm.
say a property, a neighborhood, or rural. If a petition came through and it's the neighbors that are there, and it's something that's going to interfere with their rights, shouldn't you look at that petition?
Well, you can look at it, but it's a big difference between them standing there and that they have the information. How do you know? It's like polls. Some polls are more reliable than other polls because some people do a better job of giving the questions are better, the information is better. But when someone is asking somebody to sign a petition, they're not here. And you don't know the full circumstances of what information did that person get when they were asked to sign. I could probably get my neighbors to sign all kinds of petitions, and they don't know a whole hell of a lot. They just trust me, and because I said it, I think this is a bad idea. So that's why they shouldn't carry quite the same weight. That doesn't mean you shouldn't accept them. That doesn't mean if somebody stands and says, look, I talked to all my neighbors, and all of my neighbors signed that.
So you can look into that too.
Sure.
Because it may in fact be doing that, or it might not.
Right, agreed. But it's just when you value evidence that's coming in, the value of a petition versus a value of someone who's heard everything and then says it. I'd suggest that I suggest that you can accept both of them. I'm not saying you take the petition and throw it in the trash by any means, and I've said that earlier at meetings, before you became an alternate member. But it's important that it's not the popularity contest, it's compliance with the standards of the regulations, or, you have been selected to make decisions of what you think is in the best interest of the community. And then once you educate yourself about what the regs say, you become more familiar with that, and you might change your mind about something, and that's what this whole process is about.
If someone came and we denied it
Mhm.
for good reason, because they didn't have enough information or whatever, if they came back and they still had the same information, should you leave them up?
Sure. That's the impotent to reverse rule, again, right there. If somebody comes in and you've decided that they have to have this, and the commission decides it, now you get some new members of a commission 2 years later, and you really shouldn't say, nah, that's not important anymore, if there's not been a change in the regulations. Now, I've also seen situations where commissions made a big mistake, and it's perfectly clear that somebody looks at it and says, wait a minute, this definition says that you can't have X, Y, Z, but for some reason the commission missed it when they approved this other project 5 years earlier. I'm on the commission now, and there's no way I'm going to approve it because it's flatly in violation of this plain language. What I'm not telling you to do is repeat an error, a clear error. But when there's judgment exercised and you've made a decision on the judgment and the circumstances haven't changed, you should defer to the decision that's been made before and say, this commission's already ruled on that, and not change your mind. Now, regulation policy is different. I mean, that's like the state could decide that the speed limit should be 65 and change their mind and say it should be 55. When you adopt your regulations, policymakers, you sit in that policymaker role, you can change your mind. You can, with experience, with things that have happened, you just said, I really don't think this regulation, we adopted it, but it doesn't make sense. We got to fix it, or we got to get rid of it. You have a lot of discretion when you're changing your regulations. It's more along the lines of applications where you've made a decision. You really shouldn't change your mind unless there's been a change of circumstances. I've already touched on this, so you automatic approval can happen for subdivisions and site plans. But even if it doesn't apply, try to adhere to the time limits and get your extensions. So now, I'm going to jump into some of the stuff of your role as individual members of a commission, things that you can't do. You can't appear in front of this commission or any other commission. One of the responsibilities now that you're on this commission is you can't appear before other land use agencies and be a representative of somebody else. You can't stand in front of them. Now, you don't give up your rights, your own personal rights, for your own interests because you're a member of the commission. You, of course, would recuse yourself from deciding, but if your next door neighbor is doing something that you think is in violation of the regulations, or they have an application that you'd like to oppose, you can. You can't sit, obviously, on that same application, but you can be heard on that. But what you can't do is, your neighbor, would really like your help with a variance application and would like you to come and present on your behalf. You can't do that. The statutes say that. And there's another for folks, the member of the Zoning Board of Appeals is on the line. There's a statute just like this that says that members of the ZBA can't do that. Oh, it says here too. There's also ones for wetlands commissions. So basically all land use commissions, there's a statute that says you can't do that. Now, when should you recuse yourself? All right, one is when you have a conflict of interest that's either personal or financial. Now, this doesn't mean necessarily that you in your heart of hearts, you know that your best friend, you grew up, you literally went to kindergarten through 12th grade, still get together, all the time. You in your heart of hearts, that you'd probably put him or her through more rigorous challenge than anybody else, and will be perfectly fair with the application. You have to sit in the seat back there, and would they think that you can be fair and impartial with a person that you have that close of relationship with? And of course they wouldn't. So when you have a close personal relationship, family members, someone that you're really close to, even if you think you could be fair, then you should recuse yourself. Same thing as if you have a financial interest. If it's your company that's the applicant, obviously you have a financial interest in that, and you shouldn't participate. I mentioned ex parte evidence. If you received ex parte evidence and you do it the right way and present it, then in the public hearing, then you might not be disqualified. But if you heard something and you didn't disclose it, you shouldn't participate in if you were going to rely on that evidence. I mean, if somebody tells you something and you think they're cuckoo for Cocoa Puffs, and they just said something really crazy to you in the laundromat, you can ignore that. But if you're going to rely on evidence that you received, that's problematic. And the same thing is prejudgment. you've got to be very careful on what you say. Everybody has opinions. No one, we're human, and then the court recognizes that. But this process is supposed to be decided based, just like a judge. A judge should walk in and, blind justice should make that decision based on witnesses' testimony that comes in during the course of the trial, and only that. And the same thing is true with respect to what you do, and that you shouldn't. One training thing that we to mention is somebody says that the trout fishing area in the Willimantic River for fly fishermen is one of the greatest assets in eastern Connecticut, and I am never going to allow any project that's within a quarter mile of that area. Well, you've prejudged. You stated prejudgment, and that could be a basis to challenge your vote, and sometimes to challenge the entire decision of the agency. And so, on the other hand, if you've said in a public forum that that's an important resource, and if you're going to come in with an application, you better show the commission that you're going to protect that resource. Well, that's okay. That's just showing that something that's important to you. So be very judicious and do as best a job you can consider yourself like a judge. And you shouldn't be saying things that someone after the fact could say that you made up your mind before you came and heard the evidence at a hearing. Also be careful about doing independent research. If you have expertise, if you have training in an area, you need to disclose that. If you're going to be talking in deliberations and say, look, I've been working on designing stormwater retention basins in accordance with the Connecticut Stormwater Manual for 40 years, and this plan completely misses the mark, and this is the reasons why. Don't do that for the first time at the public hearing, in deliberations. You can say what your expertise is, say what you think is wrong with that application, and that would give the opportunity for the applicant's engineer to say, well, no, I think you got it wrong, and this is why I think you got it wrong. And then ultimately the commission can make a decision, just like when two experts present their view, the commission has to decide, who's right or wrong, but at least you've disclosed that. But if you're doing independent research, maybe you've heard of something and you have some basic knowledge, maybe you have some knowledge from a prior application. Somebody's coming in and their lights are not compliant with dark sky or what have you, and it hasn't been raised, and you bring it up. I mean, that's fine. But when you start doing homework and you go into the library trying to find evidence that would support a denial or an approval, again, judges look at cases, but a judge doesn't go to try to dig up evidence. So if you really need to allow the applicant and the public to present the information to you, and you make your decision on what you hear, you really shouldn't be an advocate one way or the other on applications. Now, again, policy is a little bit different when you want to try to advocate that the commission should consider, doing, like the legislature adopting a new law. Doing homework that relates to changing your regs, that's okay. It's just when an application has been before you by an applicant seeking to do something with his or her or its land, you should do that, make that decision based on what's been presented. Familiarity with the record, I already touched on the example where, in a virtual meeting where you tried to participate and the system just went black. There's no way to get yourself familiar with the record. But for new members of the commission, and I know for existing ones, if you've missed an earlier meeting, you can vote, but you have to get yourself familiar with the record. And the way to do it in 2025 is to listen to the recording or watch, the video of the meeting so that you've familiarized yourself with what's happened. And you should state, because it'd be a mystery to people, an applicant or members of the public, if they know from the minutes you weren't at the last meeting, they'd have no reason to know that you familiarized yourself. So if you say it on the record that you've done it, and that will make the issue should make the issue go away too on appeal if somebody tried to say you weren't familiar with it. I've already touched on the fact that you can represent your own interests, and steps be taken to avoid a conflict are the things I've been talking about, sort of the common sense rule about about not talking to the applicant, or not talking, going and meeting with, there's an opposition group that's formed in opposition to thing, going, meeting them in the hallway and have the applicant stand there watching you have, a meeting for 20 minutes where they try to persuade you why it's a terrible application outside of the context of the public hearing. Well, that's an awfully good way to show that, you've got a bias or a prejudice, or received ex parte evidence. And it's just a problem. It's just like, you're here, you do it during official business, and tell folks to come talk to the whole commission, outside of the, right here, rather than, on the steps of town hall. It's when you have a conflict, and there's no, it's actually, your responsibility, your duty to say so when you have it. We recommend, and there's some law that would support that, is just don't be in the room when you have a conflict. There's actually been a case, I was actually involved in one, where a member had a clear conflict, recused himself, and the room was kind of set up a lot like this, and sat right at the end of the table and is staring at everybody, and at different times is nodding and doing these, and not surprisingly, the court found that was inappropriate and reversed the decision, even though the person recused himself. He was making his presence very well known to everybody in the room. So you avoid. No one can argue that you've influenced the commission when you're literally not in the room. Then you get the text or the email or the phone call. We've passed the matter. We're past that matter. Come on back, and you come back into the room, and you can be seated again. So when we're talking about financial interest, it's not just your personal, it can also, this is where there's a blend of financial and personal. If members of your family have a financial interest, or somebody that's really close to you has a financial interest. Now, there's large organizations in the community that, you're a member of. I mean, your kid could be in school. It's kind of tenuous to say that you can't be involved in an application in which they're looking to put a playground in, or in one of the biggest churches in town. You got to be a judge of when your relationship is too great. But there, in a small town, there's certainly going to be some times when you can be part of an organization that doesn't necessarily cause you to have to recuse yourself with an application involving that organization. But if it's a close call, recuse yourself. It's always better for the avoiding the risk to the town in an appeal when you do that. Already touched on that. Already touched on this. It's really about the perception. You in your heart of hearts can be sure you be fair, but if you put yourself in the shoes of someone sitting behind me, would they think it would be fair? And if not, then you should recuse yourself. All right, so again, the ex parte evidence, you shouldn't be talking, having the meeting outside the meeting. There is the ability under FOI for caucuses. It doesn't happens at councils and boards of selectmen and that sort of thing. Doesn't tend to happen with land use commissions, but technically under FOI, there can be a caucus where you talk amongst yourself. It's very rare. I already talked about what to do when people come and try to approach you about something that's on the application. So some do's and don'ts under the FOI about electronic stuff. Text change, emails. If you're communicating with one another, that's a meeting under the FOI. Now, there's an exception if what's happening is staff sends you notice by email of this is what the agenda is, and that kind of communication, and you write back, well, what room is it? Is it, did we have to, because of the elevator, do we have to, go to the other meeting room? That wouldn't turn it into a meeting. But if, the agenda goes out and one of you says, oh, I cannot believe we're going to consider that application by that knucklehead again. Didn't we decide that last month? Well, you're going to turn what would otherwise just be information about a meeting into a meeting because you're communicating about business of the commission outside the context of the public. Be careful with things like Facebook posts and other social media things. Those could be classic examples of prejudgment. You shouldn't be weighing in and taking a position until the end, until you've heard all of the evidence. So if you're out there making posts about problems with the application or the applicant or something else, then it doesn't it doesn't make it seem as though you're going to wait until you hear all the evidence to make that. And even, I might be dating, I don't know what you call X's and re-X's with the world of Twitter versus X, but even liking social posts that somebody else makes, that's the same thing. You're endorsing someone's position on an application. That could be evidence that you've been prejudiced. As I mentioned, hearing from the public on policy, that's something that there's a little less risk about doing that. But the less that you do that, and the more that you do it, again, you're not going to see a judge, soliciting a bunch of information in public. You have more of an opportunity to do it here at the meeting, so bias is where you've expressed personal feelings or favoritism. Predetermination is where you're suggesting that to vote. The cases talk about where the public hearing is essentially a sham, that it doesn't matter what you hear at this public hearing, you could never be persuaded differently. If you've done something or said something prior to an application that signals how you're going to vote, that's just a classic way in which a judge could look at that and say, well, you already made up your mind. And be careful with your words. There's an old case where I'm convinced that it was all in jest, but you can't tell because your words are going to be written down on paper. Sarcasm, humor, all that stuff. Even though things are recorded, the typical way in which stuff is presented to the court is just simply a transcript of your words. And there was a case where folks were making Italian. It's a 50-year-old case, but there were a bunch of Italian jokes that were being made. The applicant was Italian, and the applicant was able to demonstrate that there was a hostility towards him as an applicant because he was an Italian American. And so that case was an example of, you could be doing something and joking around. Just think about how it would look if all the words were written down. Are you suggesting that you'd have a bias towards someone who's trying to get an approval, or frankly, someone who is advocating against one, and trying to keep that level of decorum up at all times? More and more I'm seeing some actions by members of the public, and sometimes even commissioners among themselves in different commissions, where people are getting a little more aggressive than they were 10 or 15 years ago. You have to set a tone of how the decorum. People have to stay on message. It shouldn't be personal attacks. There shouldn't be shouting, yelling, and you create the kind of environment and do it amongst yourselves as well. I've been in front of this commission plenty of times, and that's not the way you behave amongst yourselves. But I have been in front of others where not so much. So that you can set the tone by the way you behave amongst yourselves, but you can also make sure that you've set the tone in terms of the way people are presenting to you. That doesn't mean people can't be passionate about a position. That's not what I'm saying. It's just the way in which things can cross that line into personal attacks. And pointing at an applicant sitting here and someone is at the podium and is pointing and trying to accuse the person of being a bad person. That's not the merits of the application, and you need to try to keep it on that. You should, again, this ties again into predisposition, publicly taking a position regarding how you're going to act on an application before you've heard it. You just can't do it, because how can you have open mind if you said how you're going to rule on a person's case? Again, I'm going to continue to use the judge analogy, but imagine if you were about to try to convince a judge that you didn't commit that crime, and they said, well, we know you did it, but come on in, go ahead and tell me what you have to say. That would be a totally inappropriate on the part of a judge, and same thing would be true for you. So when you do disqualify yourself, you're doing your duty. There's no shame involved. If somebody is, you're not familiar with the record because you didn't have time, you had a busy week and you couldn't listen to the tape. There's no crime in that. If you do have a close relationship, somebody doesn't know that, rather than I'm going to recuse myself and it's a big mystery to everybody, you recuse yourself because this is an old grade school friend, or this is this is a business partner of mine, or this is my first cousin. And you say it, people are going to understand, people are going to recognize that you take your responsibility to be unbiased seriously. So putting it on the record really helps, and it helps me if there's ever an appeal and I have to challenge it, when a judge looks and sees that you've taken your responsibility. And the other is true also. Nobody in the commission can tell you can't vote. It's your own responsibility. There can be no vote among the commission that says that Commissioner Thurlow has a conflict, he can't vote. He has to make that decision. But if he states on the record, if somebody challenges, somebody says something, if you think about it in your heart of hearts, you know that you're able to be fair, and you say on the record why. A court will pay attention to that you're doing responsibility. That doesn't mean you're guaranteed you won't be found to have had a conflict and the decision all gets reversed. But if somebody challenges you and the situation is remote, it's like, I went to first grade with that person. I haven't talked to them in 40 years. And so I don't have any close relationship with that person. You can make it clear on the record, and the judge can pay attention to that. So, kind of touched on this already. The chairman is in control. I said before there was going to be another slide. This is it. There is no right of a public to be heard except during a public hearing. The exceptions is on a case-by-case basis. If somebody, you're trying to decide how to handle timber harvests, and one of the most experienced timber harvest guys in the state happens to be a Killingly resident who happens to be sitting in the audience and is willing to give you some insights. Well, even though it's not a public hearing, you can ask them to provide you some information. That's your discretion. You can allow that. But the other ways is if you set on your agenda that you have public comment, or you adopt a rule that you allow public comment. Those are the ways people can do that. But those rules can be changed. Robert's rules, they can be used. The Robert's rules has a giant exception in it, which is really largely meant for big bodies. Like when you have a big town meeting and you got a moderator who has to try to figure out, make sure motions are clear, having amendments to motions be decided on very clearly before, have the ability to divide the room or have paper ballots. All those things deal in Robert's rules with larger groups. But it says in them when you have a smaller group, the rules are more relaxed. Robert's rules actually says you don't even need to have a second for motions with an organization your side. It's traditional that in Connecticut, commissions like yours will always have a second, or just about always have a second. But Robert's rules themselves say you don't even need to do that. What matters is that you're able to move business. So I haven't seen it with your commission, but I have seen it on some commissions where somebody tries to use Robert's rules as a sword to try to not move business, but kind of try to make a point of order all the time, and just kind of interfere with business. That's something you need to avoid. You use the rules so that you know what's being voted on. The public knows what's voted on, and that's what's clear. Will become clear in the minutes, and that's your motions. It's a good idea to restate the motions, or if staff is assisting you and it's a written motion, that can make things easier. But I've seen your commission put together some complex, relatively complex conditions to motions, and you've worked it through, stated it clearly, it's been repeated on, it's been voted on, and it shows up in the minutes, and you do a good job with that. I've touched on, I think I've touched on pretty much all of that. I mean, there's this part of this slide where I mentioned, exhibits and logging them in. Your staff does a good job with that. If somebody comes in, and nowadays this is less, it's become so rote because of post-COVID, but it used to be a point where people would come in and do a video presentation or have photographs and not actually give the organic copies of those electronic files, so that if there ever was an appeal, you can't include what was doing that. So you need to make sure you get those, and your staff does that. Already touched on that. Tie votes, I said before, if you failure to get the necessary votes to approve, it's a denial. So a tie is a denial. There are times for a supermajority. For the ZBA member, there's always a requirement for a supermajority on their votes. You have to get 4 affirmative votes on all ZBA votes, except for things like move their agendas and things of that matter. But for variances, which is their bread and butter, or appeals from enforcement decisions, they have to have 4 votes. Supermajorities only come in based on petitions to, the remonstrance style petition, where the proper number of qualified people oppose a district zone, a change of zoning district that can require a supermajority. So was the end of my presentation on that. Sure. Well, that's what the stump the attorney slide's all for.
At a public meeting,
Yep.
if 3 or 4 people came and there was a really important issue, and we all felt it was important, but it can't take up the time, is there a way that we could give them another date to bring that to us? If everybody felt it was a serious matter, than to just send them home. But I can see where we wouldn't let them take up all that time, because we have other people.
Sure. I mean, if there's some important public issue and your commission decides,
Everybody felt it was-
yeah, you can put it on the agenda and hear from people. It's your prerogative. It's your commission, and so that if you think that there's something that you want to hear more from the public on, you can have an agenda, even though it's not a legally required public hearing, because it's not a special permit application or a zone change, but it's something that you think you should get feedback from the public. Then you have the ability to do that if the commission wishes to. The chairman sets the agenda, but if you suggest to the chairman something that you think should be on there, then he has the ability to put it on the agenda and allow for that. Any questions on any of the stuff that I covered, or didn't cover for that matter? So you had a member, should we touch on, I'm sorry.
Would you
Yep.
repeat that, the number of votes needed for a zone change, please?
A zone change is a simple majority. But there's a statute that allows, it's somewhat complicated, and you had one that was really complicated that we spent some time trying to figure out exactly whether it was met. But there's a statute that has a number of persons within a certain distance of a district change. If they sign a petition opposing the change of district, not a regulation change, but a district change, then that can require a supermajority. But other than that, it's just, for planning and zoning matters, it's a majority of the quorum present is what is necessary to pass a measure.
Couple questions. So, modification versus conditional approval. So, do we need to be specific in the type of approval that we're granting? Because sometimes we do small modifications of a plan, like you need to add this detail something, but you were talking about modification, approval with modification versus approval with conditions. Do we need to be very specific when we have those types of approvals?
You don't have to be specific in describing whether it's a condition or a modification.
Okay.
It kind of is what it is. What's clear, what's most important is that it's clear. If you are, what you're approving, what you're changing in the application is clear, then that's what really matters.
Okay,
Now,
so if we said approval with conditions and some of them were modifications, that would be fine.
that'd be fine.
Okay, wanted to make sure we're clear in the language.
Yep.
Next question is the specialized knowledge disclosure, right? So all of us have backgrounds in different criteria, and a lot of times I'm looking at things in an engineer lens. Given that I'm a professional engineer, do I need to state that every application? Or should this board do something like put small bios on a website that the general public knows what our backgrounds are?
See, the fact that you have people who end up on planning and zoning commissions often, not always, but often have some backgrounds that lend them, the fact that you're putting in the time and your paycheck's pretty light for spending the time that you spend here, that it's usually people who have an interest in that and some ability and knowledge. On a general matter, no. But if it gets to the point where you see that you have, like it came up before. I mean, I've been in meetings where you wanted to know what the cuts and fills are on a project, and you want some detail about that. You don't have to say that you're asking for that because you have some background in that. But if it became to the point where you were going to bring some of your training to bear to question and make a decision about where you're bringing it's different than your training. Your training might give you the ability to apply your regulations effectively, and that's fine. You don't need to say, I'm an engineer and that helps me to do that, or I'm a surveyor that helps me to do that, or I have knowledge because I'm in the the real estate business. But if you are going to bring some specific knowledge to the table, and you are going to raise that during deliberations and say, look, I'm a trained engineer, and I know that when you apply Boyle's law to the way that this with this piping system is going to work, it's not going to operate properly, and we're going to run a risk of a fire. All right. Well, you're going another level. That's not just you having your ability to be able to analyze the evidence. You're bringing something from your own training to the table. When that happens, that's when you should say, I've been trained in this way, and I know from my training that this is a problem with that element of the application. Can you please explain why I'm wrong? That's when you need to do it. On a day-to-day basis, the fact that you bring certain skills to the table that you buy out, you don't need to put that on the record.
Okay, all right, thank you.
Anybody else? Somebody from the public wanted to speak. Oh, should we allow it? Go ahead, Anne Marie, first.
Can you just clarify? Thank you, John. Can you just clarify this predisposition? I'm going to go way back before I even came here. Cell phone towers, when they were still being done by the individual towns. There was a board member that said, and he wasn't even at a committee meeting. It was like a neighborhood meeting. And the board member said, I will never, ever vote for a cell phone tower to come into town.
Exhibit A
Okay.
of predisposition, prejudgment. I mean, that's exactly the difference between that, the Willimantic River reference I made that said that this is important. If somebody said at cell towers, I'm concerned, I want to make sure that if you're going to locate a cell tower, these are the kinds of things that need to be addressed by an applicant. That's suggesting that there's things that they want to see, but they don't have a closed mind about whether they approve them. But if you say that I will not approve, or I will approve every one of these things, then what's the point of the public hearing? And so that's a classic example of an inappropriate statement that the person, every time a person says that in a public forum, every single time cell towers, as you say, are siting council now, but every time after that a cell tower came up, a person should recuse himself or herself.
Well, that just leads to council's interviewing of the latest group. Then the question I heard was, would you vote for, what was it? Something in rural development, a higher density in rural development, something like that.
Mm-hmm.
Now, that's a direct question to the applicants. Now, if they had the answer, so now how do we treat that? We just, let them decide later whether to act on something if it comes in?
Well, I mean, if it's an application that could be coming in front of your commission, my recommendation along the lines of what I'd said earlier was I have to wait until I hear all of the evidence to decide how I'm going to vote
Right.
on that, and defer.
I'm sorry?
Actually, when we were asked, I said, I've looked over all of your issues here, and I said, I really can't make a vote tonight because there's not enough information.
Right.
Then there was one that I said, in this case, I might look at that, but I don't know because I haven't had enough information.
And that's a good way to handle it. And I mean, you can blame me too, in a sense. I mean, and I've said it in an earlier training session because we had a lot of these slides were part of but I also had some of the substantive zoning stuff, so we kind of blasted through some of these slides a little quicker when we did the presentation, when I did a training last year. But, that's just saying how you're going to vote on something beforehand is a bad idea. So if somebody asks you to publicly state what you're going to do on an application, I recommend that you say, I don't know. I mean, you said something along the lines that, I recognize we're a rural community and there's things we got to make sure that we do to protect it. If that's your opinion, I mean, there's some inkling of your opinion. I don't think there's anything wrong with just saying, look, I can't tell you. I'm going to decide things once I hear all the evidence,
Right.
and just literally push away from that. But if you did get into some of your philosophy of some of your opinions, that's probably okay as long as you're broad enough to do that distinction, like I made before. These are important resources. I'd want to make sure that we weighed everything carefully before we voted. If you got into a little of that, that's probably okay. But so my recommendation would either say, hey, I can't tell you how I'm going to vote because I need to keep an open mind so that I'm able to vote when the time comes, or just be relatively vague about some of your some of your perspectives. That would be okay. But the less said, the better, because we don't want to be spending time and then taxpayers' money defending a decision that's been made on the grounds that remarks were made earlier that were prejudged an issue.
Does that mean that you reserve opinion until the very end, until everything's been said?
Sure, although, I mean.
Rather than
Yep.
use it as a means to achieve whatever you think should improve an application?
No. During the course of an application, when somebody presents something
Is it
that.
improper to say, as presented, I couldn't approve it as presented because I believe that,
Right. And it
This
depends.
should be addressed.
It depends where it is in the process, John. Because if what you did is you said that before the applicant made a presentation, then it's clear.
I'm not talking about during.
I know.
I'm talking during the application process.
Yep.
During the hearing process. If a comment was to be made that, as presented, I wouldn't be able to approve it.
Right. And you folks do that in an appropriate way. After you hear from the applicant makes its presentation, the public heard something, and then you start talking, and you say, I have a real problem because I don't think that the buffer area is sufficient over here because that neighborhood is too close, and that dialogue is, and it's only your view. I mean, it's not the whole commission.
Yeah.
But if you're doing that based on evidence that's been heard during the hearing, and the applicant can respond to it. But it's a kind of a timing thing too. If you come right out of the gates with that perspective, if you're coming right out of the gates with I'm really concerned about the neighborhood and you're general and you want to do that's probably less of a problem. But the more information you hear, and then you give some feedback, it gives an opportunity for the applicant to make some modifications, that's okay. You don't have to keep your mouth completely shut, wait till the whole thing's over, and then say denied because the buffer should have been 15 feet wider when the applicant, had they realized it had been a little wider, would have made it wider. That's not good practice either. So you can, the kind of dialogue you typically, that I've seen you have with applicants is okay. You're doing it after you're hearing information and you're sharing it. And sometimes you don't agree with each other, and that's okay too. When somebody says, I think this should be fine, and somebody else says, no, I think that's okay, and then change each other's mind. That's the nature of the deliberation. But if you do that after you've heard presentations, that's showing that you didn't have a closed mind before you waited till you heard it all, and then you raised some of your concerns.
Anybody else for questions? Can we have an objection to open up to the people on the floor?
As I said, that's your prerogative. So.
Is anybody against that? You want to vote?
Okay with it?
Go ahead, John.
John LaBelle, 57 Island Road, Dayville, Connecticut. Thank you for what I consider to be an excellent presentation. I practiced as an expert witness for 12 years and still do. What I want to answer the question partly that Brian asked. Be careful if you hold yourself up as an expert witness, because you cross a line of liability for yourself if you do so, and you can comment on that. But if you all of a sudden say, you know, I know more about this than you do because I've practiced at this, that, and the other thing, you have to be careful that that doesn't cross the line where you suddenly became an expert witness. And also, you all are entitled to bring in an expert witness when you run into a situation of engineering or something that has to be practiced. The second thing I wanted, actually the first thing I wanted to say, I'm always cognizant of the personal liability that people on these boards and commissions take on, sometimes realizing it, sometimes not realizing it. And a while back, I started asking questions of corporations when I was an officer of a big corporation. Are you going to give me a cell phone and a computer? Because your cell phone, your computer, becomes evidence in a lawsuit. They take it away from you. Everything on that device that you think is personal might become public information. So the question I have is, why are we not protecting board members better with the electronic? And I would encourage you to include the use of electronic devices, whether you're at home or especially your personal. I know of a situation back a few years ago, before cell phones became so popular. A person was on his home phone. Someone had a receiver sitting outside of his home recording his call. It ended up in a lawsuit because of what that person was saying about another person. But my point is, can you please give us advice as to how we should be using electronic devices of our own personal nature? Because, you know, I've been involved in cases where the computer was subpoenaed, the phone was subpoenaed, and everything they said became, at that point, public information in a court of law. And so I always caution. And then, of course, it's the use of personal vehicles for town activities. Would you please advise us as to where the line is drawn in terms of if Keith Thurlow gets in an accident while, in the middle of a meeting, he gets out in an emergency, he jumps in his car and goes to something, and he gets in an accident on the way. Now, I know what the insurance says, but typically, I've never had a good answer from a corporate attorney on, if I use my car on company time, what's my liability? So I have, as an officer of a corporation, I always requested a company car. I was fortunate enough to be entitled to it. But those that are not, that jump in their car. One day, and it's my last comment, one day I was in charge of a $1 billion corporation, a casino for a weekend. Lo and behold, I get a call at 8 o'clock in the morning. One of our employees has just been run over by another employee. She's laying on the ground and he's gone. They're both tribal members. Try and sort that one out. Thank you.
Glad you recovered from your circumstance. There's a few things in there. In terms of the electronic device usage, there's one thing that didn't touch on that I'll caution against, and that is, and I've not seen your commission do that, but there's commissions that are sitting, and one of them actually, in a settlement with FOI, had to say at the beginning of every meeting that their laptop that they were using and or their phone, they were using it for the limited purpose of reviewing the materials, the agenda materials for that night, and for nothing else. Because they obviously, and I wasn't involved in the earlier thing, I was involved in the application, but they were sitting and they were communicating with each other. Somebody's nodding at that end of the table and somebody types, and then somebody's nodding at this end of the table. So they were having a meeting within the meeting, and they got caught. And so you have not seen your commission do any of that, but that's something to be cognizant of. You shouldn't be communicating the whole purpose of the FOI is the Sunshine Law, where everybody sees what you do and what you say about a matter. So if you're communicating with each other by text, that's disclosable. And the same thing, there is, this involved not a P&Z, but involved a town manager in a town who was, late in the evening was joking around with a police officer. It was a town manager and a police officer. And when there was litigation later involving the police chief, thousands of texts were made public, which included some very off-color comments that had been made, totally in jest, but you didn't want these things to be put out in the public. So, if you're texting with two people on the commission, texting each other, might not be a meeting under FOI, but in some circumstances, some litigation, it's correct. There could be an opportunity that your laptop or your device would have to be reviewed. And public, if you are commenting on public business, it's really a public record. So you've got a public record that you shouldn't, under Connecticut law, you can't destroy. So be careful if you have the ability, if you do keep things that relate to business of the commission in a either segregated device or in a segregated manner. And there's no guarantee if it's on your personal device and you put it in a separate drive on your device. That might be satisfactory to a court who might not require that anything be disclosed other than the separate drive that you have, that you will testify under oath or an affidavit saying that that's where you segregated everything. But it's possible that judge isn't sure and wants and gets it all reviewed. So you should be careful how that was a very good point. Be careful of how you're using your devices, because things can be subject to disclosure under either FOI or, if there were civil litigation, under rules of discovery. You do have protections as a public official. It could be a whole night's presentation in terms of immunity that's afforded to you. The state has what's called sovereign immunity. The king can do no wrong. So you can't sue the state unless they give you permission to, with some exceptions in terms of constitutional protections under federal law. But a municipal officials are generally afforded what's known as governmental immunity or limited immunity, so that things that involve your judgment, those things you are provided, you are indemnified for, and the town has to provide a defense to you most of the time. Again, it'd be a whole long evening of some exceptions, so there can be some real wrongdoing that you're engaged in, and you might not have the defense have to be provided to you. But generally speaking, the municipality has to do there. I can't speak to the nuances of using your vehicles and at what circumstance that you should, I recommend get your own attorney's advice about how much insurance you should be carrying on your vehicles. But I don't know the subtlety about whether or not the Planning and Zoning Commission is going to a site visit in their own personal car, whether there's any liability associated with that. I've not heard of any cases, but I don't do, I'm not a defense lawyer on personal injury and haven't seen a case involving that. So I don't want to give you an opinion about that, because I frankly just don't know either. So I apologize. I joined with other lawyers that you've gotten bad answers from about not knowing the answer to that one. So, but other than just making sure you have good insurance on your car, I think you're covered.
So is there any place, I was a local person that was on a Board of Ed in another town, and she ended up having to hire her own attorney for some defense ethics commission thing. So is there any place that we're not covered by the town's legal system, lawyers or protections, I should say?
Well, I mean, there can be. I mean, if you're stealing from the town, or you're unhappy with your discussion with Brian, and you go out in the hallway and get into a fist fight. So there can be some instances where your conduct is outside of your official official duties where you're not going to be provided a defense. But there's a pretty broad net on that. So more often than not, you're going to be provided a defense. And in some instances, an individual might there might have to be separate counsel for an individual and a separate counsel for the body or the town, and both of which paid for by the town. So more often than not, a defense will be provided. There's often a reservation of rights that in the end, if your conduct crosses a certain line, then the insurance company is not going to cover the damages, but they'll at least provide you a defense. But there are a lot. The law tends to try to protect public. People that do what you do, so there are a lot of protections in place. If you're just in good faith trying to exercise your responsibilities as a member of commission, there's a pretty broad net in terms of how you get protected, both in indemnification and immunity. It's really when you engage in real wrongdoing where there's some issues.
Any other questions from anybody? Well, thank you, Ken. I appreciate it. I think it was very helpful.
Pleasure. My pleasure.
If Brian beats me up in the hallway, he's picking on the elderly.
Keith,
Ma'am.
I just want to remind Lorraine and Norm, if you have not done so already, and you too, Michael, because you've been,
What?
if you've not done so
Yes.
already, that you need to go to the town clerk's office and get sworn in.
I'm sworn in.
You have been sworn, okay.
I haven't. I was wondering if that was required, because nobody said anything about it.
Yeah.
That is required, so,
Did you, Mike?
and we didn't
No,
have
no,
anything
we-
for you to vote on tonight, so you're fine. And Michael, same thing for you, you've got to get, okay?
Tomorrow.
Okay, motion to adjourn?
Motion to adjourn.
Second?
Second.
Plenty of seconds. All in favor?
Aye.
Opposed or abstentions? Good. Thank you, everybody.
Thank you so